It's a breach of fiduciary relationship because I have this relationship with my banker, and he has an obligation, arguably as my fiduciary, not to steal my idea. Here, in breach of fiduciary obligation, ask yourself, what is the relationship between the vet and the buyer? There is none. So it's like privity, it fails. And that's true whether the report, in my opinion, is put in the repository or not, because where it is irrelevant when one considers the predicate question of privity. It doesn't make any difference. Now, it might seem worse, look worse, feel worse, give me a little bit of pause that it happens there and not in the repository, but you either have privity or you don't. Now, that leaves two causes of action that would catch my attention in my interview with you, Knox. And one of them is the one identified by these gentlemen, negligent misrepresentation. And that's the one that bothers me the most of all of these. That's the toughest one. That's the one you need to put your thinking cap on. And we concur with each other, I believe, in that regard. Here are the elements of negligent misrepresentation. Think about them now. Think about them. The defendant, whoever it is that you want to sue, in the course of his business, his profession, or in any other transaction in which he has a pecuniary interest, he has a money interest, supplies false information for the guidance of others in their business transactions, and failed to exercise reasonable care or competence in communicating that information. And the plaintiff justifiably relied upon that information given. Now, the real concern about negligent misrepresentation is the cost of it. The cost of the defense, the cost of the prosecution. It's heavily fact-oriented. You think back through those elements, they're facts, reasonable care, exercise of competence in communication, false, true. They're all facts. That's expensive. There's no questions of law per se. It's very well settled. That's the expenses on the fact side, the depositions, the interviews, the trials, that's the problem with the deal. Now, the last is fraud. It smacks of negligent misrepresentation. It can, as these gentlemen said, be a material misrepresentation or a material omission. Has to be material, but it can be either. So, particularly when the consignor starts the conversation and then omits something material, it's very problematic. It's like you lead somebody to think greatness and then you don't tell them about the problem. That can be fraudulent. But it has to be false, it has to be known to be false, or it has to be made recklessly. It has to be made with the inducement to be acted upon by this horse. The plaintiff has to act in reliance. It has to cause injury. Now, it's a tough case to bring as a plaintiff to sue a seller or a consignor. You have to be specific in your allegation of fraud. You have to prove your allegation by clear and convincing evidence. And that's sort of important. If I try a lawsuit for you, I'm the plaintiff, I'm in state court, I've got to get 9 out of 12 to buy my side of the deal, right? And in a fraud case, I have to prove each element not just as more likely than not. 51%, it's more likely that they knew of this condition and didn't tell me than not. That's not what fraud's about. Fraud is clear and convincing evidence. It's a heightened standard. I oftentimes describe it as 75%. So it's not just 51, but it's not 99 like in a criminal case. You've got to be careful about imputed liability. The act of the consignor can be imputed to the owner. I would suspect that under very certain circumstances, a vet who works for a seller could get mixed into the mix, but it would take particular facts to do that. Again, what I worry about in these things is the cost of it all. I compliment the sales companies. Conceptually, they have done what they can do, I believe, to try to dispute resolution in-house. You all know about the rejection and period. You know about arbitration. You know about as is. You know about the request of every buyer to examine. All of those things fit. And as long as someone cannot successfully challenge the conditions of sale as a contract of adhesion, and what that means is something that is so one-sided that it's against public policy. And I've never seen a successful attack on conditions of sale on that ground. Bain, I don't think you have either, have you? Or Bain, I'm sorry, Boyd. So I mean, it's not, they're very well crafted, and I think they're designed to limit this kind of litigation. And I'll conclude by saying this. Do you take reports out of the sale? In my personal opinion, you do not. The conversation about standardizing the reports, making them better, I agree with. It would be nice to make them better. I don't know how you make them better. I don't know if the science is there yet, but your efforts are really important in that regard, and I concur with that. Do you mandate that every buyer has to have their own vet for a pre-sale? As a buyer, I would say no. I don't believe that that's appropriate. I feel like, I'm an American, and by God, I can do that if I want to do it, or not do it if I don't want to do it. And then finally, I really think this is all about balancing the needs of the marketplace versus the need of, quote, no risk. And it's a business judgment that you all have to make. And that's why meetings like this, in my opinion, are so important, and I appreciate the time that you've given me to speak to you. Thank you.
Just before we wrap this part up, to either Mike Casey or Mike Meusser, do you have any additional comments before?
I'd just like to say I think the lawyers up here pretty much agree about where the exposure lies with these reports. And the difficulty for you as participants in the industry is to try to decide how to solve the problem. I don't agree that the conditions couldn't be challenged necessarily with the use of these reports, because there is case law in Kentucky that Keeneland and Fasig-Tipton have responsibility for the accuracy of the information that's supplied to the buyer. So I think if, we haven't had one of these cases, and I think the only reason we haven't is that the book 1 and book 2 horses, people are probably doing their due diligence, and it's gonna take an expensive horse and somebody who's really upset to bring one of these cases to court. But I do think when one comes along, everybody's gonna be in the mix. And it is going to be multiple causes of action. And I agree with Bill that on the contract side of it, the vet and the seller really aren't in any danger of exposure on these reports. It's these other claims that can be raised.
From my standpoint, the conditions are great for challenges that are brought or disagreements that are brought before the horse leaves the sales company. 75% of the cases I get involved with are issues that have been discovered a week, 2 weeks, 6 months later. And then they're challenging, when the horse doesn't develop the way people want it to develop, there must have been something wrong with the report or the scope or something. And the conditions don't provide that type of protection in civil litigation. From our standpoint, from my standpoint, when I talk to the veterinarians about when they ask me, what do I write down? And I tell them I can't help you with that. I can tell you what your exposure is based on what you are writing down, if you're expressing opinions or not. I always return to, that there is a balancing of the equities here, but the problem with the law is you can do everything reasonable. You can have an honest opinion of what you believe affects the horse's ability to race. But under Kentucky law, if that buyer has a different opinion and relies on your report, you have potential liability. From the veterinarians, there's a couple other things that pop up. This is a hot button topic with the Kentucky Board of Veterinary Examiners, as it needs to be. And they do an excellent job policing the industry when they have a complaint, and they file things because they need more information at times, and there are times that they've sanctioned veterinarians and there are times they haven't. But something else happens to a veterinarian when they are found to have violated an ethical rule and there is some sanction from the Kentucky board. Every state that veterinarian is licensed in then has a handout. So, every state with your ethical rules has provisions that say if you violate an ethical rule of one state, it is a violation in our state. So we've had situations where we've had radiograph disputes and there's been a small fine paid, and the next thing that veterinarian gets the same letter from Florida and Maryland and New York and California and Texas, and we're litigating that same event in 6 cases in 6 different states. So it is a problem from the veterinarian standpoint. As we showed in our period, they're the ones that are most at risk, and they probably have the least control as to who sees these reports.
One of my best friends is a guy named Jon Famularo. And Jon Famularo is a lawyer. He just passed away a year ago or so, 6 months ago. Fabulous lawyer. His dad was a judge in Robertson County. My people are from up that way, and I asked Judge Famularo why he became a judge, and he said he was the only lawyer in the county, and he couldn't figure out how to make a living because there was nobody to argue with. So he became the judge, and then he had more than one county to do his business. You and I come from different worlds. You represent vets. I represent breeders and consigners. I think it'd be great if the forms, the science could improve the forms. I think it'd be super. I'm not preaching doom and gloom to y'all. You know, I don't see it for most part. I mean, there is a way that somebody can take cases like this to court. Doors are open. It's a cost of defense problem that I see, not necessarily an ultimate win or lose problem. One other statement about disclaimers, and I think Mr. Meusser mentioned this, but I want to emphasize it. When the vet puts the disclaimer at the bottom of that report, okay, to me, what he's really saying to anybody other than his seller is, hey, I didn't contract with you to do any work, buyer. I contracted with the seller. He's really just re-emphasizing the lack of privity concept that we discussed in breach of contract, breach of warranty. But I must say this. If a consigner sees that disclaimer and knows well that the veterinarian isn't working for the prospective buyer, you know, doesn't that give us all some pause? You know, that we're sort of furthering a potential misuse of information. And I'm not saying it does or doesn't, but I would guess that most of the people that I deal with who consign, it gives them a little pause because they know that they're not living up to that disclaimer from a professional who issued a report. You know, and I know that if I issued a legal opinion to, I mean, I probably represent 50 of you in here, and I gave you a legal opinion and you started passing it around. So where's the elephant in the room? I mean, obviously, is it practical for me to think that that legal opinion, I should be paid for it 50 times? Is it right to think that you're going to pass around my legal opinion? And that's the dilemma that you have to, you might walk away from here and discuss when you are looking for a solution to the timely topic. Nux.
I just have one question. It seems like sales catalogs and conditions of sale have grown in the last 2 months. And there is a condition that deems the buyer to have knowledge of all elements that put in the repository for that particular horse, which means as a consigner, if I do my work, get my 32 reviews, get my report, all that's put in on that stamp, then that should be the condition of sale and not give that person a right to come back and contest that sale because he refused to go follow up on what he was deemed to have knowledge.
I agree, but Mike, you might want to talk to that.
I think the problem is that when all that was in the repository was the films, that was true. The whole problem with the reports is it's an opinion about what's on those films. So if all that was in the repository was like we had it originally, you just had those 32 films and you look at them, I agree with you. The conditions take care of it. The problem is the body of law that we're all worried about goes outside the conditions if there's something in the report and that opinion that can be argued as misleading, incomplete, or just wrong. That's the problem.
And the creation of the arbitration process recognizes that.
Right.
There would be no need for an arbitration process if that condition gave the ultimate protection, because it recognizes there's another item to this, there's another element, there's a report. And since those reports are used in reliance, since the report is in the repository, well, we now get to see if that report was truly reasonable.
And that's why they put in that arbitration proceeding that you only get arbitration if there's something in the report that is materially misleading or doesn't agree with the films. That's how we got there.
But I'd be for all four if that standard applied for what you said. That would be perfect from my perspective. But the reports have kind of moved it away from there.
Well, we got clarity on that subject, right? Let me thank everybody on this panel today for debating both sides of this issue, which continues to be a paramount in the sales process today. In order to keep on with the schedule, we're going to end this panel. We'll take about a 10-minute recess, and then we will come back on our panel with Syndication and Big Stallion books. Our next panel is going to be related to early stallion syndications, how it's involved into large stallion books. We have quite a distinguished panel to help with this presentation today. We're going to start with Jon Jones. Jon, you came out of Quanah, Texas, trained quarter horses, worked for the legendary Walter Merritt, Marvin Warner, and with a little help from Robert Sangster, started Walmack Farm. Jon was instrumental in stallions like Nureyev, Alleged, Wet Luck, Shecky Green, Monteverdi. You probably had 100 stallions since 1975 as stand at Walmack, so I know there's a lot of history in there. Why don't you give us just a little bit of history, starting off with Nureyev? You know, Nureyev's a horse.
Well, I'll have to apologize to you guys, because at my age now, I keep remembering things I want to forget and forgetting things I want to remember. But Nureyev was just a lucky deal. I've been very fortunate. I don't know why I've been in the right place at the right time, but actually the real story why I got Nureyev was I was with Mr. Head, Mr. Chambour, and that was when Mitterrand was supposed to be the minister of France, and they were saying he was going to be a communist and socialist. I just said, well, they may want to get some money out of there, so I called them, and they did. So I got to do Nureyev, and then the first 14 mares I bred to him, all of them came back. So the rest of his career, we bred him around the clock. But we got it done, and he was a very successful horse.
He also had a little bit of an injury in his career.
Well, he stuck his leg through the fence, broke his back leg right in the hock, and the only thing I had to do with that really was just be a cheerleader. The only two decisions I really made, I asked Dr. McGee not to take him out of the surgery until I could build the barn about 100. I didn't want him to go into the clinic where there were other horses, so he agreed to that, and I got a little barn built for him about 100 yards away from the clinic. And then when we got ready to move him out, there wasn't a trailer or a van or anything in Kentucky that you didn't have to step up in. So I knew there was one in New Orleans, so I called Louis Russell, and he shipped a truck and that trailer up here that would let down flat on the ground, and that was the most expensive 100 yards ever in the horse business. So we got lucky, but in all essence, Dr. John Howard was the savior of Nureyev, and then the guys that worked there, I mean, I was just a cheerleader.
Rick, you had a long association with E.P. Taylor and Winfield Farms in Canada, very instrumental in moving Deputy Minister, the minstrel Imperial Falcon, down to Kentucky. Very instrumental. It started in 1986 with W.T. Young's Overbrook Farm and Stormcat, but we'll certainly evolve into that and touch on that in a little bit. Can you tell us just a little bit of your association and when you first started bringing horses into this area and your association with Brookdale Farm and how those horses managed to make it into central Kentucky?
Well, I started in the horse business working for Fasig-Tipton, and that was in the 70s, and I met Fred Seitz, who was working in our Kentucky office. I was in the New York office. Excuse me. And Fred and I developed a friendship, and when I was ready, nearing the time when I was ready to leave Fasig-Tipton, and Brary Jones bailed me out of New York and hired me to be a business manager at Airdrie. Fred and I decided to start owning horses together. And fortunately or unfortunately, bank loans were pretty easy to come by in those days. I was just making a modest salary at the time, but I could still borrow a lot of money with a modest salary. And we forged a good, successful, long-term partnership, breeding, wheeling and dealing, whatever we could do to try to make money, until I got nervous and jumped on the Broodmares Anonymous bandwagon, or wagon, I should say. So when I decided after a few years at Airdrie that I wanted to start my own business, I was doing a lot of consulting at the time. I just hung up my shingle. I thought, just like a lawyer, I could bill my services out. And I was foolish to think it was that easy to come by, but I was very fortunate to strike up a friendship with a very well-known, famous bloodstock agent from England named George Blackwell. And George was very close to the E.B. Taylor family, and George recommended me to the Taylor family to help them. Joe Thomas, who had run the operation, had just died. And as Johnny says, a lot of it is to do with luck and being at the right place at the right time, and not making the wrong moves, which I had opportunities to do and fortunately didn't. So I started just as a consultant to Winfield's, and when I went up for a meeting and met with Charles Taylor and their VP Finance, we went to Maryland, and they asked me if I would run the entire thoroughbred operation in Canada and Maryland, and I said yes. And at that same trip, at that same time, it was decided to retire Northern Dancer from breeding. He pulled a Nureyev of over 14 or something like that, and what was ended up being his last year. And I think he was 26 at the time. And they were going to have mares lined up, and they rightfully, I think maybe two mares got in foal to him. I forget the exact number, but it was a very small number. And it was at that time I was announced to the employees that I was going to run the operation. So without the Northern Dancer income to subsidize, a widespread operation like that, it made it very clear that they needed to close that operation down. So we looked at the stallion roster, and we decided the ones that we thought could do well in Kentucky, and that was, as Bain said, Deputy Minister, whom just totally by coincidence, Fred and I were very keen about him, and we bred our own mares to him even before I took the job with Winfield's. The Minstrel, of course, how could you not like the Minstrel? And Imperial Falcon, who was an $8 million yearling. I think he won a race or two, but he didn't have that much ability. So we moved him thinking that if this horse hit, even at a $5,000 stud fee, when he stood at Fred's farm, he'd be popular. And he was popular until he didn't get runners, and then, like any other horse, he's forgotten. So that, we moved the minstrel to Overbrook Farm. Overbrook was I'd been doing consulting work for Overbrook for about a year at that time, and I felt like they had the right image for an international horse like that. We moved Deputy Minister and Imperial Falcon to Fred's. Fred was just starting his stallion operation. I think he had just one stallion, Greenton, if I'm not mistaken. And this followed up, and by standing those stallions at those farms, Winfield's could still retain the image of being the syndicate manager, which I managed the Stallion's books. But the farms also got the visibility of physically having those horses there. So they were both great partnerships. The minstrel died after a few years, sadly, but we ended up bringing Silver Deputy down from Canada, which was another story unto itself, down to Brookdale, and both Silver Deputy and Deputy Minister had very long, successful breeding careers at Winfield's, and the relationship between the Taylor family and the Seitz family was a very strong relationship up until the last horse died. I don't know if I went way beyond what you wanted me to say.
No, that was, actually, that was perfect. Jon, you're Maryland native, trained horses in Maryland, went to work for Helmore Farm, syndicated horses on a regional level. And something I remember, I think you read, or that you wrote, it was the end of 1978, bell bottoms and long hair and sideburns were in style. Bee Gees were at the top of the charts. And the Baltimore Colts still played in Baltimore, where they belonged, I think were your words. It was also about that time Seattle Slew showed up 3 years into your reign of Spendthrift Farm. You want to elaborate on that just a little bit?
Oh, I'd be happy to, but first of all, I've got to ask if any of those lawyers are still here. That if after this talk, any of you find out that I've told some lies, you will not sue me. I've had a great run, and I started out in Maryland. I was rubbing horses for Billy Hahn, a very important man in my career. He was a trainer for Helmore Farm, and it is through Billy Hahn and the years that I spent with him and a couple before him on the racetrack that taught me something that is hopefully still with me even though I'm retired, and that is, it taught me horsemanship. In 1967, Mr. Lucas bought a farm in Howard County, Maryland, and he asked this young guy, John Williams, who was just a groom, if he'd like to manage his farm. So that was a big leg up. And as Arthur Hancock once said, if you see a turtle on a fence post, you know he had some help. And that was my big leg up. We syndicated a few horses at Helmore, and Mr. Lucas was a businessman. He was not a horseman. He loved the game, and I don't know why he thought I could syndicate them, but I called Tyson Gilpin and found out how syndications were done, and we did horses like Roanoke Island and Rock Talk and you know, a few horses like that, and then we stood a horse called Laugh Aloud and Tambourine, and these were names that I'm sure none of you ever heard of, but they really gave me my background in stallions. I came to Spendthrift after a long time at Helmore. I came to Spendthrift at the insistence of a great friend of mine, Lee Eaton, and he asked me to interview for that job. I did. I didn't think I wanted to do it. He asked me to take another interview with, at that time, Linda Combs. And after 45 minutes of her hammering on me, I said, if my wife says it's okay, we'll come here. And I came to Spendthrift in '76. I planned to stay here 3 years. It's now been 40. And that was one of the best 45 minutes I ever spent in my life because it turned things around and took a kid from Howard County, Maryland, and put me on the big stage. Shortly after I was at Spendthrift, I was sent to France to pick up a stallion that Brown Combs had just negotiated to purchase for the farm. His name was Caro. Some people called him Caro, but Caro was his name, and he was a successful horse. He was sire of 2 champions in France, and I had a check for $4.2 million, and there's a story in itself, and that was my first encounter with a world-class stallion. Shortly after that, as a 3-year-old, Seattle Slew was doing everything that a horse could possibly do. And Lee called me and said, "John, you know what? If Spendthrift has any real interest in getting this horse, you better get those guys down to Hialeah right now and talk to them." So we made a trip to Hialeah, watched Slew annihilate him in the Florida Derby. The Flamingo, and he was a 3-year-old. A deal was struck, and the Hills and Taylors retained his racing, all earnings from racing. They kept half of the horse. There are other players that were involved in this. Was Joe Lehman, a longtime friend of, they grew up with Mickey Taylor in Yakima, Washington, Franklin Groves, and a few other key players. And they raced that horse as a 4-year-old, which is, I to this day, can't thank them enough for their sportsmanship, because the insurance premiums were so excessive that everything that Slew owned, just about everything that he earned, went to paying those insurance premiums. Now that's sportsmen, and that's one of the things that we don't see as much of today as we did then. So Slew came to Spendthrift after his 4-year-old championship career, and we let him down, and it was a tremendous day when he arrived at the farm. You can imagine a Triple Crown winner coming to the farm. We had already had 2 Derby winners there at that time, Proud Clarion and Majestic Prince, but now we've got a Triple Crown winner. So he was a $12 million world record syndication, and after we got him let down, we brought him to the breeding shed to test breeding, and we had a terrible realization that we had a problem. And I called Mickey Taylor and I said, "Mickey, like they said in that movie, Houston, we have a problem." He said, "What is it?" I said,